Pausing here for a quick word from our sponsor, Fourth Party. If you're serious about building a real business, not just a practice, you need systems that work as hard as you do. That's where Fourth Party comes in. It's built specifically for dispute resolution professionals, and Fourth Party is the all-in-one back-end platform that handles your intake, scheduling, file management, payments, and more, so you can focus on doing the work that you love. And because you are a listener of the Practice Playbook podcast, you can get 20% off your first 3 months. Just visit fourthparty.app and use the code Susan20 at checkout. Take control of your business and start building it like a CEO with Fourth Party. Welcome to the Practice Playbook podcast, your go-to resource for legal professionals, mediators, and entrepreneurial experts building modern, profitable, and purpose-driven businesses. I'm your host, Susan Guthrie, attorney, mediator, and #1 best-selling author with over 35 years of experience. I'm a former chair of the ABA section of dispute resolution, and I've helped thousands of professionals build practices they love through my books, coaching, and training programs. Each week, I'll bring you real-world strategies, mindset shifts, and behind-the-scenes insights to help you grow with clarity, confidence, and impact. Let's dive in. Welcome back to the Practice Playbook podcast. I'm your host, Susan Guthrie, and today we are diving into what I think is one of the most exciting and for many profitable developments in dispute resolution practice, and that is early dispute resolution, or EDR. So if you've ever wondered how to expand your services, stand out in a competitive market, and deliver even greater value to your clients, then this episode is for you, because we are talking about how adding EDR to your toolkit can benefit your clients and your bottom line, and how to market this innovative process in a way that truly resonates. To explore all of this, I am joined by Ann Jordan, a Chicago-based arbitrator and mediator of counsel to the firm Mandell Menkes LLC, and a leading national voice on early dispute resolution. Ann serves on the American Arbitration Association's commercial, large complex case, employment, and international panels, as well as the CPR panel of distinguished neutrals. She has handled countless high-value cases involving technology, IP, and employment disputes, and she previously served as general counsel for 3 major technology companies: PeopleSoft, Sega of America, and Worlds of Wonder. And also a trustee of the EDR Institute and the past chair of the ABA section of dispute resolution's task force on early dispute resolution. So she's been shaping how this process evolves from the inside out. Together, in this episode, we'll talk about what EDR really is, why clients love it, and how you can use it to strengthen and grow your practice. By the end of the conversation, you'll know exactly why adding EDR may be one of the smartest business decisions you can make as a dispute resolution professional. Well, Ann, I'm so happy that you are here today and that we are talking about this really fertile area of practice that I suspect many of my listeners have a glancing understanding of, or think they understand what early dispute resolution means. But I'm excited to really dive under the surface with you. So thank you so much for joining me.
Well, thanks, Susan. And, we've trained a lot of people on EDR, so there are a lot of people around the country that are already using EDR in their practices, but it's still a developing area, and it's still something that some people are still learning about. So it's important to get the word out and get this into really the next level of mediation.
Yeah, I'd like to see it myself as something that is just a natural part of our training. I see EDR as something that could be folded into the 40-hour and maybe make it a 48-hour or something like that, or EDR skills built into that process for mediators, because I think it's that essential. It's a skill set that's really essential for a modern practitioner.
Well, it really is. And, as you do more and more EDR and incorporate it into your practice, if you look at then how that compares to traditional mediation, you just think back and you're like, why did we ever do it that way? And why are people spending so much time being trained on traditional mediation practices when early dispute resolution has a higher success rate and really provides a lot of additional benefit to the parties in terms of understanding their case and their ability then to make really sound decisions about settlement?
Well, I think that's a very important point that you make, Anne, is that these skills and this process of what we're calling EDR is something that has a proven track record, that has statistics involved with it. It's not just this nebulous concept of a process. There's actually a formula or a procedure or a process that you follow when managing an EDR mediation or an early dispute resolution process. So maybe we should start there. Can you explain just on a basic level so that those out there who are listening who don't really understand what we're talking about can understand what you mean when you say EDR?
Well, if you look at how EDR got started, there were efforts to promote early settlement because most cases ultimately do settle. So the question is, if you're really headed towards settlement at some point in the case, why wait? Why put yourself through the time and expense of discovery and motion practice if you can actually settle early? So of course, everybody's like, oh yeah, I love it. I love the idea of settling early, makes a lot of sense. And then how do you do it? And the early focus was more on, just the concept of trying to settle early and just initiating traditional mediation early. Then in some cases, the process was talk to the other side and come up with your own process. Well, here you are, in a dispute with somebody, and now you're going to try and on top of that, negotiate some kind of structured settlement discussion. So anyway, fast forward to 2019 and Peter Silverman, who came up with the EDR process. And it's a 4-step process. It sounds simple, 4 steps, but there's a lot of nuance to it and there's a lot of thinking behind it to make it work and to overcome the downside to traditional mediation and the issues in traditional mediation that make it difficult to lead to settlement early in a case. And so what are those? Well, the first step is in EDR, you need to understand your case. And a lot of times people wait until the case is really heated up to get a good understanding. And having been general counsel for 3 corporations and been through a lot of disputes, what you need to do is to really understand what your position is, but what the other side is saying. Because if you don't, you miss a lot and you get way too far into it and you've spent a lot of money when maybe you didn't need to. And then the second step of EDR is exchanging information. So if you have a situation where you don't really understand the other side's position, you need more information. A lot of times in employment cases, that's the case because the employee has all this information about, the things that happened in the workplace. And it's very hard to, as you go up the chain to find out what happened. And then the third case, the third step is risk analysis, which uses decision trees to objectively value a case. So you can say, not just, oh, gee, I think this would be, 500,000 is the right number to settle. You can actually put numbers to it based on what the likelihood of winning is, what the potential damages are, and come up with a formula that tells you here's what that number would be considering all those things. And then you have negotiations. And the negotiation in the 4th step takes place serially. So it's not a one-day event where, if we don't settle by 5 o'clock or 6 o'clock, we go back to litigating. It goes on until the parties feel that there's no further point in continuing discussions. So those are the steps, and that's what we're talking about with EDR.
And just as a clarifying point, when in the process would you start with the 4 steps? When in the conflict process, so to speak?
Well, you could start before a case is filed. You could start, around the time a case is filed, or you could even start later on. So the benefit, obviously, is the earlier you start, the less aggravation you have with litigation and the more money you save. But there's no specific time. I think that it's a particularly valuable tool for people who build in mediation as a condition to filing a lawsuit or filing arbitration. Because if you're going to have that kind of process, why not use EDR, which is more likely to succeed at that stage than requiring as a precondition just traditional mediation. So it's an opportunity to get to EDR in a way that is already set out in an agreement. So, I think that it's an important tool that you can build in at that stage. But long story short, it can be used at any point.
Really at any, but the benefits, perhaps, the earlier,
oh, sure,
the better, right? And it strikes me, I was just, as you were talking, I was thinking about, I wrote a paper for the AAML journal last year. They had asked me to contribute a paper on the benefits of EDR in family law practice. And one of the things that I had pointed out about coming to the table early before litigation had that opportunity to do what it does, which in all cases, but certainly in family matters, the discovery process, motion practice, all of that really just ramps up the conflict so that by the time we would get to mediation, which in family law very often happens a couple of weeks before trial date, as a last ditch effort to settle, the old settle on the courtroom steps, everyone by that time is so angry at each other for all the intrusive discovery and questioning each other on the expenses and the accounts and all of that, that it really made it that much harder to settle. And I would imagine that's in most any litigation. The further you've gone in the litigation process, the more that the conflict has been fed by the litigation process.
Well, absolutely. The other thing, though, that happens in traditional mediation when you have one day that's devoted to trying to negotiate and resolve a case, first of all, it's not a lot of time. And then everybody is, in their respective conference rooms waiting for the other side to respond while the mediator goes back and forth. And if it takes a party a long time to come up with a settlement offer, the other side, I find, will be offended because they've been waiting for 3 hours in a windowless conference room and without much to do other than just complain and commiserate with their counsel about how poorly they've been treated. So you get to them after, maybe a couple of hours of trying to get an offer out of the other side. So you finally go to present the offer. And now, instead of being focused on the dispute that everybody came to resolve, you're trying to talk them down off of being offended because they've been sitting there for 2 hours with no offer. And so, as I always say in mediation, we're here for one dispute, so we're going to take it back to the one dispute we're here to focus on. But, it's a process that can create hurdles, in the middle of trying to settle another dispute. So I think that the idea that a lot of it can go on in EDR virtually and that it takes place over a period of time makes that, is one of the things that contributes to the success of the process.
Yeah, I as a family practitioner, we sort of have two models of mediation. One is that full day at the last minute, we're going to stay here until we get this done. Everyone's fatigued and and unhappy when we leave, but at least we're done. Or we do a series of sequential, smaller meetings where we go through a couple of issues. And then when people start to fatigue, we regroup and come back. And it sounds like EDR is more along that model, which gives people time, space, and the ability to work through things, hopefully without ramping up all that negativity or leaving anyone sitting in a conference room for 3 hours.
EDR, again, is a documented process and it's 4 steps, but it's flexible. So, if you don't need to do one of the steps because you've already had discovery, so you don't need to go through the full information exchange process, you've got what you need, you just go on to the risk analysis. So it is flexible and it depends on, both where the parties are at a given time and what they want to do. What is best suited to them in terms of a process as well. So it's adaptable.
Well, and I think that's important for people to understand, right? Because when they hear process, people do tend to start thinking a rigid process, and having that flexibility means can be curated for each case with the skill and understanding of the mediator, right? So I think it's important that people understand that the mediator plays a big role in an EDR process. I know a mediator always plays a big role, but in this particular case, I see it more as a conductor of a symphony, or, making sure, because as you talked about those steps, and the one that really jumps out at me, I have to say, Anne, is the information step, because I know that for so many attorneys, especially in the process of the litigation, if they don't have full and complete discovery done through sort of traditional means, they can feel that it's dangerous to settle, or there's an issue with settling because they don't have every single scrap of information. And so that's a very knee-jerk reaction I hear people say when EDR comes up as an option. So what would you say to that?
2 things. First of all, just at a very general level, there are statistics that show out of all of the documents that are produced, how many end up as exhibits actually at trial. And it's just an infinitesimal amount. So if you look at I have a slide on this, I don't have it in front of me, so I can't actually give you a number for infinitesimal, but it's very small. Lots of zeros to the right of the decimal point. So if you look at the cost of having to preserve information, and then what's preserved is, then there's a lower subset of that. It's what's actually collected, and then what's actually reviewed, and, on down. And then what ends up being an exhibit is a handful of those documents. And so you do need some of the, larger document collection and the culling down process to get to what you need. You can't just go right to the 500 documents you need for exhibits, but it's a very inefficient process if you just look at the data. So, what that says is that people can hone in if they want and get the documents that they need to understand the case. We're taught as litigators, most of us come up as litigators, and we're taught, to be successful, a discovery request gets everything. And so, when you finish drafting your discovery request, if you have been able to ask for everything so that there's absolutely nothing that could be excluded, you've done your job. And here it's the opposite. You need skills that tell you this is what is important. So then how does that relate to EDR? In EDR, you ask the parties what is it they need, and some of them will give you a request or express a request that looks like, we're already in court and they're already serving discovery, and you have to explain, this is an important part of the EDR neutral's role, you have to explain that that's got to be narrowed down. But again, you have to put it in perspective in terms of what the parties need. And the whole point is to be able to make an informed settlement decision. Anyway, the EDR neutral does pull back the parties from this, I need more information and more information and more information. And so, we've all had cases or mediations where, one party just can't get there. They just are still very uneasy without like what they think would be the full picture. But my answer to that is, make a settlement offer that you're comfortable with. And maybe you err on the high side because you don't have all the information, but you've got to start somewhere. And the EDR process gives you a lot of direction and information to be in that position.
Right. Well, and I think that one of the big factors that and perhaps people need to be reminded of it throughout, but one of the big factors is there are many benefits to EDR that go beyond just the monetary settlement that will be finally decided upon, right? There's, and you said it earlier, you were in-house counsel, for three companies, that getting these conflicts, getting these cases off the books, resolved early, quickly, in a way that is expedient and satisfies everyone. There's a lot of major benefit to that client, but there's a benefit to the attorneys. There's a benefit to the clients. Everyone benefits if they can resolve their case early.
First of all, in not all cases, but in many cases, the parties have some kind of ongoing relationship. And, when they don't, if you end up in litigation and it's just a slog and everybody's fighting and the whole tone of everything is confrontational, that's less of a consideration if you have an ongoing relationship. Then you're just talking about, let's save the time and money and aggravation of litigation. But where you have an ongoing relationship, the longer litigation or arbitration goes on, the more difficult it is going to be to get everybody back into the fold, so EDR can help with that by trying to get people back together and course correct early on in a dispute.
Yeah, I think that's, certainly, again, being a family practitioner, the less you have to drive the conflict between the couple, and then they have to go forward to co-parent or continue to be a family in some ways, that's all to the best. What would you say the benefits are for the attorneys involved, for the advocates involved in EDR?
Well, it's a huge issue for clients in terms of the cost of dispute resolution. And they're under pressure if you're in-house counsel or, even outside counsel, you're under pressure to resolve disputes cost effectively. And it's very frustrating for clients in litigation because you can't control the spend. You can up to a point, but you can't control, if you're in the middle of discovery, for example, or you're in the middle of motion practice, you as a party, you have to respond. So you can't say to your counsel, as you would like in another situation, I only have another $2,000 to spend, right? Because you can't be that precise. So, for counsel, it really gives the client more control over the process, because they're involved in a process that the client can understand, that supports client self-determination, helping a client through that and get things settled is positive, I think, to have a practitioner who has done that. Now, when I was in-house counsel, I would be the client at mediations, and what would happen would be I would have spent usually months with a litigator feeling confident that we were on the right side of things, and we get into mediation and the mediator would go, what you think about this? The outside counsel that had been with you through the whole time would go, I think we should, and then the mediator would leave the room and your attorney your outside counsel would be telling you, I think we've got some issues here and we need to think about this and think about that. Your reaction would be just like, who is this person? They came in here like my best friend and my support system. And now, they're telling me things that I hadn't heard. And if you hear them from the mediator, that's fine. But to hear them then when your own counsel is going, there's a problem there. And so I think it's an opportunity for counsel to avoid getting into that situation because the process is about evaluating, understanding and evaluating your case. And that happens in a relatively short period of time. The process contemplates, 30 to 60 days, start to finish. And so you don't get into a situation where for months you've felt pretty good about things and you've been spending money thinking at the end of the day, there's going to be, some benefit or something positive that comes of that. And to get into mediation and all of a sudden your counsel is going, yeah, I think, paying the other side $500,000 is not, is not a bad outcome. Not only impacts how you feel about that particular case, but it can have, it can damage the relationship in other ways.
Oh, I can imagine. You add that extra zero onto the settlement figure, suddenly you're going to get your client's attention. I've seen that happen myself so many times in a mediation, or even as the litigation starts to go along, and that's what drives people to mediation right before they get into court, because the realization comes along. But now you're, 2, 3, maybe even longer years down the road from when that case stated. And I want to jump back to something you just said. What's the normal time frame for an EDR case?
It certainly could be less than 30 days, depending on how complex the issues are and where the parties are. It could be more. So on average, we use a range of 30 to 60 days. But, if you had a particularly complicated case or the parties needed more documentation or something, and that was warranted, the neutral thought that was warranted, or in some cases, the parties might have an issue that would benefit from bringing an expert in. They might hire a joint expert. I mean, they could hire their individual experts, but those tend to, sort of cancel themselves out, and there may not be a lot of benefit to that. But, the parties might benefit, if you have a situation where it's unclear, like in a manufacturing process or in a product defect process, what happened, it might benefit from an expert clarifying the factual part of it. So it could take a long way of saying it could take longer, but 30 to 60 days is not an unreasonable expectation, start to finish.
I mean, that will perk up clients' ears, certainly, in the realm of, 30 to 60 days versus 3 to 6 years, which some litigation can take. And I think that's a significant factor is, I say this I do a lot of training on marketing and thought leadership and that kind of thing. And one of the things I'm always reminding our colleagues of is at our core, we are professionals. But at our core, we are service professionals. We are providing services to clients, and having happy, satisfied clients is a core element of us having a successful practice. And so when we can remember that for them, bringing this to a conclusion in a way that they can live with in a relatively expedited timeline can be a very significant factor, whether they're the injured person, whether they are the in-house counsel, whether they are the insurance adjuster who needs to close their books, whatever that might be, that is a very big factor for the client to have.
And what it does is it focuses on really forcing a realistic assessment of the case. Again, it sounds simple, but if you look at how a lot of times people approach a case or a dispute, they'll just hear from one side, or they'll hear from the people who are most implicated in the dispute. So the person who negotiated the agreement that has now gone, completely off the rails. So their view of what happened in the negotiation and what they told the other side and that kind of thing is going to be from the perspective of someone who is afraid they're going to get blamed for this. Not that they're not important, because they will be a witness, of course. Not they're not important in this process. But I think you have to approach the initial analysis of the case as though you're investigating some compliance issue. Because if you approach it from, this is what these people say we did, But of course we didn't do that because we just don't do that. We're better than that. Or they think we didn't perform, but that's just ridiculous. We've worked harder for them than we have with anybody. And so if you approach it through a lens of, sort of a partisan lens, you're not going to get the full story. And so that's the first part of it. From the very beginning, you have to be realistic in how you look at things. And EDR tries to formalize that. And then you have the risk analysis, which then has counsel putting a percentage to the likelihood of winning. So I know, again, having been the client, if you're optimistic about your chances. So if somebody were to say to you, gee, there are some tough spots here, but I think overall we're in good shape, your mind just goes to 90% or something. And that's not, under any circumstance, the right way to look at it. But there's a certain confirmation bias that comes into that. And that's where you go. So anyway, this tries to even out those biases and tendencies so you get a more realistic perspective. And, with that, then you make, again, back to the better decision making.
Right. And you've mentioned, it sounds simple, these 4 simple steps. It's simple, but it's quite nuanced. And I think people, in hearing that you discuss this, can see that this is quite nuanced. And in fact, there's the EDR Institute that helps people, that does trainings specifically on how to properly walk through and process in this 4-step process for EDR. Can you just tell everyone, so that they know about it, more about the EDR Institute?
Sure. So the EDR Institute was founded in 2019 by Peter Silverman. He's a litigator partner with a firm in Toledo. And Peter and I had been on the ABA's task force for early dispute resolution, and then it was turned into a committee, and we were on the committee. Peter chaired the committee. So there was a lot of thought leadership that went into looking at early dispute resolution through that effort. And then Peter in 2019 took it to the next level, and he wrote the EDR protocols, which laid out the 4-step process, and founded the EDR Institute. So the EDR Institute's a nonprofit organization that trains neutrals. And so far, we've trained both the Institute itself and in conjunction with the AAA, we've done some joint trainings, well over 200 people nationwide. It keeps the protocol process updated. So those are the 2 primary functions of the Institute. And we have at this point a program in Harris County, which is Houston, Texas, where EDR is used as one of the options for the parties in terms of the mandatory settlement, mediation, or EDR. And there's also a judge in the Eastern District of Michigan that's using it in his court. And it's being taught. Peter and one of the other trustees, Michael Hawash, are teaching EDR. So that's what the involvement, that's what the Institute is, and what the trustees are doing. I'm one of the trustees as well.
Well, and I think I want to mention one of your good work in the ABA with the EDR task force, and then the committee resulted in Resolution 500 2 years ago, where the American Bar Association has in fact endorsed early dispute resolution, and which was a very significant, I think, gold star on all of your hard work and efforts. And you've also mentioned the AAA. And I think another indicator of really the growing awareness of the benefits of EDR is that AAA is going to be launching an EDR panel in the coming year. I wonder if you could share a little bit about that.
Sure. The AAA, as part of their mediation services, they're looking at expanding those services. They're putting together an EDR panel, so it will be, a subset of the mediation panel. And so parties will be able to opt for EDR And if they do, they will get someone who has been trained by the Institute in the EDR process. And part of that training focuses on using the risk analysis tools. So when I talked about the risk analysis being an objective process, coming up with, quantifying the potential settlement values of the case, that's part of it. So it will be the EDR process as the Institute publishes it, but through a panel that the AAA makes available to people who use their services.
Well, and I think that's very exciting and a true indicator of, when AAA, our leading organization in the dispute resolution field, is so confident that this is a growing trend and a needed space that they put together a panel and promote the training of it. I think that's something significant for us as practitioners to understand. And one thing that I want to be certain that we touch on, because I think it's so important for practitioners to know about EDR. They hear me all the time on this podcast talking about diversifying their services, taking their skill set and finding different ways that they can support clients so that they can bring in more clients, bring in more revenue sources, et cetera. And EDR can be brought in as an additional service you could offer. But I think it's also very interesting because you said to me, or it can be the new filter through which you run your mediations or another tool set for your mediation process. And in fact, you mentioned when people come to you, what they're getting is an EDR process in many cases.
That's right. Now, parties always have some, a lot, well, not always, but a lot of times have some view as to how they want the process to work. And so you're always accommodating that because that's their preference and that's why they're coming to you, with a certain ask. And so that's fine. But I go through the 4 steps, basically modifying the process as I use it to fit into what they have asked. So it typically is not very different case to case, but, I think the steps are important in any effort to mediate a case. Or settle a case. People have got to understand their case. They've got to have the information they need. They should certainly understand the percentage chances of winning. Because, when you're doing mediation, both parties come in generally in a traditional mediation and they both think they're going to win. And they think that what their purpose there for the day is to convince you they're going to win. So you will go to the other side and say, they have convinced me they're going to win. So, cave now. This is an effort to move people off that, right?
I think they hope that's what's happening as you walk over to the other room, but right. Secret, everyone. That's not usually how it rolls.
When I was the client, that was, for a long time, I saw that as my role as the client was to just pound on the mediator that, I was right, they were wrong, and just like another 15 minutes with the mediator and we'd get this, they would understand the clarity of my viewpoint and bring closure to the whole thing. It is something that I think more and more will become the norm. If you look at back, 20 years, a lot of people, mediation was somewhat unusual for people. So I think people are now very accustomed to mediation. It's always in the mix. And I think then EDR is the next level. And that's what we're moving toward.
Well, and it's important for people to understand this is not a static field. Mediation is different today than it was when I started mediating 20 years ago, and it will be different 20 years from now than what you and I are doing today. It is a field that is constantly evolving, as is the litigation field and all of the related areas that we're in. So for a truly future-focused practitioner, knowing these trends and staying on top of them and implementing them into your practice structure is really critically important for the future success of your practice.
Right. And I think back to, the fundamental client concerns are to reduce the cost of dispute resolution. And if you look at the trends, there's more and more litigation that's filed typically. And when you're the client, if you have an in-house legal department, you can't just increase your staff in lockstep with the additional litigation burden. And so you've got to find smarter and more efficient ways to reduce the litigation load and expedite the dispute resolution.
One of the things I think you mentioned, it might be a great thing to end on, is that cases that are approached through the EDR process have a high settlement rate.
Right. Now, we don't have specific statistics on that, but, I know from my own practice, it is a process that is much more likely to result in resolution. And that's both because the parties get the information in the information exchange, step number 2. They get a better idea of realistically of what their chances of winning or losing are, what the outcome may be. And it's a process. So it's not like at 5 o'clock, everybody goes home and well, it's too bad that didn't work out, right? As people understand it more and more, it will become the norm. I also think there's, a lot of benefit as the cost of litigation results in a lot of disputes being just not economically viable in terms of being resolved through litigation or arbitration. It's a process that can give you some relief if you have a dispute that's just real, very real to you, but not economically big enough, sadly, to be redressed in court.
Well, yeah, for businesses, this is a bottom line, number for them. And so I think that this is such a fascinating area. I honestly could talk to you about it for another couple of episodes, but I want to make sure that we give everyone the information. So I will include both the links to the EDR Institute as well as to your website, but would you like to give your contact information here so that someone can reach out if they don't have a chance to go to the show notes?
Sure. So it's Ann Jordan. My email is ann@annjordanassociates.com.
Great email. Very easy to remember, everybody, but I will put everything in the show notes for you. But reach out to Ann if you have queries or interest, or you're looking for a fabulous EDR mediator. So, you never know.
And I just want to reinforce that the EDR Institute and the training, which we have traditionally done live and will continue to do some live training, but we are going to have training on demand available later this year. So for people who want to be trained, get the EDR training, they'll be able to do it that way.
Oh, that's a fantastic option. So what I'll tell you all listeners, watch my LinkedIn. I will announce it. I'll ask Ann to tell me when the on-demand goes live, and I'll announce it on the LinkedIn and the newsletter. So be sure to follow along. We'll make sure you know all about that so that everyone can get their EDR training. So, Ann, I very much appreciate your coming on and sharing your insights and wisdom with my listeners. I think this is, one of those emerging areas, and I know you've been doing it for a long time, but I suspect for many of my listeners, this may still be an emerging area, and I hope they're hearing all the many reasons why both they and their clients want them to get EDR trained.
Well, thanks, Susan. It's been great talking with you. And for your listeners, feel free to reach out to us and look at the website for the EDR Institute if you want more information or have any questions.
All right, as we wrap up, let's highlight a few of the golden nuggets from this conversation with Ann Jordan about how early dispute resolution can transform your practice. First, EDR isn't just a process, it's a business advantage. By helping clients resolve disputes faster and with less cost and stress, you create happier clients, stronger relationships, and more referrals. Second, The earlier you get involved, the better. When you introduce EDR before the litigation machine ramps up, you save everyone time, money, and frustration, and you position yourself as the proactive problem solver that clients want on their side. Third golden nugget, EDR is a flexible and adaptable process. Whether you use it as a standalone service or you weave its principles into your existing mediation work, it gives you a structured, proven framework that makes you more effective and efficient. And finally, EDR professionals are in demand. As more organizations, courts, and even the AAA recognize its power, those who are trained and ready will have a clear advantage in the marketplace. All right, everyone, if you've been looking for a way to stand out, serve your clients better, and grow your practice in a way that feels both modern and meaningful, early dispute resolution might be your next step. A huge thank you to Ann Jordan for sharing her expertise and insight, and for her leadership in advancing EDR nationwide. If you'd like to learn more about the EDR Institute or how to get trained, you'll find links in the show notes along with Ann's contact information. And don't forget, she mentioned that on-demand EDR training will be launching soon. So be sure to follow me on LinkedIn. I'll share the details as soon as it's live. As always, everyone, thank you for listening to the Practice Playbook podcast. If today's episode got you thinking about new ways to grow your practice, please share it with a colleague and leave a quick review. It helps more professionals discover the show and join our community of future-ready practitioners. Until next time, everyone, keep learning, keep growing, and keep building the practice of your dreams. Thanks so much for listening to the Practice Playbook podcast. If you enjoyed today's episode, I would love it if you'd take a moment to leave a review, follow the show, or share it with a colleague who's ready to build the practice of their dreams. If you want more support and tools like the ones you heard today, join the waitlist for the Practice Accelerator, my brand new subscription program packed with resources to help you grow smarter. You can find the link in the show notes or visit susaneguthrie.com to learn more. Until next time, stay focused, stay intentional, and remember, success starts with the right playbook.